Good morning, good afternoon, good evening, depending where you're joining from today. Thank you for joining our weekly live discussion to discuss all things related to digital transformation. My name is Eric Kimberling. I'm the CEO at Third Stage Consulting. We're an independent and tech agnostic consulting company that helps clients throughout the world with their digital transformation projects. And we also help them de-risk their digital transformation projects as part of our service offering. I've got a great guest for you here today, a great topic. I'm really excited about this. This is a very different topic, something I've never covered before on this podcast. It's I would say it's an idea. It's a thread that's in its infancy in the industry, but something that's very important to the enterprise technology space. And that is the topic of legal shifts, regulatory pressure, and the future of ERP and cloud decisions. And the reason we want to talk about this topic here today is to talk about some of the emerging trends that are happening from a legal perspective that we think might impact the enterprise tech space. And it certainly should be something that you as enterprise tech buyers and leaders should be aware of, just to anticipate what this might mean for the industry and some of the changes that might be coming in the industry. We'll get into this here in just a moment. But before I introduce our guest and get into the topic at hand here, a couple of quick housekeeping items. First of all, we're streaming live right now to LinkedIn, YouTube, Facebook, X, and TikTok. So wherever you're listening or watching, thank you for being here today. Thanks for being part of our live production of this podcast. We'll take this interview, we'll edit it, we'll add some additional content to it and make it a part of our formal Transformation Ground Control podcast that gets released every Wednesday. So keep an eye out for this in a forthcoming episode. You can go to transformationgroundcontrol.com to see all the past episodes that we've done over the last 5 years on this podcast. So speaking of the last 5 years, you're probably the most frequented guest that we've had on the show over the last 5 years. In fact, I'm 99% sure you hold this title, Marcus. That is Marcus Harris, who's an attorney with Taft Law. Marcus, thanks for being here today.
Yeah, well, good. Once again, I'm glad to be here. And, I think, my frequency really goes to the topics that you're talking about. And it's just right in my practice area, my interest area. And I think you're one of the few, if not only, technology agnostic consulting firms that is putting out this kind of content. And I think it's a real benefit to the community, to the users. And I mean, from an educational standpoint, I mean, it's really, it's helpful to people, and I'm glad to be a part of it in a small way.
Yeah, likewise. Yeah, glad to collaborate with you again on yet another episode. This is probably at least the sixth or seventh time you've been on this podcast over the last few years. And you do the same. You put out a lot of content. If you don't follow Marcus, be sure to follow him on LinkedIn. He's got a YouTube channel as well. He puts out a lot of great content, video content in particular. But before we dive into the questions that I have for you, Marcus, tell us a little bit about yourself and what you do at Taft and just sort of your upbringing in the enterprise tech space.
Yeah, for those that don't know me, my name is Marcus Harris. I'm a partner at Taft out of their Chicago office, Taft, Stettinius, and Hollister. I focus my legal practice on drafting and negotiating software-related contracts, with a particular focus on large enterprise software deals and all the collateral agreements that go with those. And I've developed a real sweet spot in litigating these types of disputes when they go sideways. I mean, depending on the study that you look at, I mean, digital transformations, ERP implementation projects fail at, anywhere from 70-75% of the time. And I think it depends on how you define failure, but there's certainly a lot there that comes across my desk, and we're involved on a virtually daily basis with either negotiating these contracts, litigating them, and we litigate against everybody, SAP, Oracle, Infor, all the names that you heard of, and a lot of the second, third tier names that you may not be as familiar with. But that's what I do, and like Eric said, I've got we put out a lot of content from an educational standpoint, and it's something I hope your users check out and they find value from.
Yeah, absolutely. And, the topic we want to talk about here today is really an interesting one. And you and I were talking before we went live here today for this interview about how this is a pretty, it's a new topic. It's emerging. You and I don't have all the answers because it's such a new thing. And we're starting to see little smoke signals of things that might be coming in the future, in the not too distant future, and things that are emerging in this space. So this is not based on our typical conversations that you and I have had in the past around the current law as it stands today, around a specific lawsuit or lessons from lawsuits. This is more anticipating what might happen from a regulatory perspective worldwide. And there's a couple instances we're going to dive into in here in just a second that potentially foreshadow what might happen in this industry. But I'd love to hear from the audience too. I have two questions for the audience before we get going here, though. For those of you joining and listening here to us live, if you don't mind, just drop in the chat. First of all, what city and country are you joining from? I'd love to hear what city and country, what part of the world you're in, just so we can understand, what regulatory regime you might be a part of or report up to. But also, I'd love to hear just a simple yes/no question from the audience, just to maybe trigger some debate or conversation here. And that is, do you think the enterprise technology space should be or needs to be more regulated by government regulators? It's just, we're going to dive into that topic here today. Not to give our opinion necessarily, but to talk about some of the regulatory changes and shifts that are shifting in the world that lead us to think that might be something that's coming, whether we like it or not. So I'd love to hear from the audience here. What do you think? Yes or no? Should we have more regulation in the enterprise tech space, or is everything fine and we can self-regulate and we're good to go? Love to hear your thoughts on that. But a couple things we want to dive into. There's really two primary regulatory shifts that we want to dive into. One is fairly directly related to the enterprise tech space. The other one is not related to the enterprise tech space, but it's related to the consumer tech space. And as I think you would agree, Marcus, typically business to consumer type stuff, anything that's consumer facing, typically will get regulated first. It's going to get the attention of regulators and government officials before B2B. And I think for whatever reason, governments just don't feel as bad for businesses when they get screwed or if they're taken advantage of, but they do feel bad when consumers get screwed. And let me start with the consumer one, and then I want to come back to the more directly related one that's directly related to the enterprise tech space. And there's something called the Digital Markets Act in the EU. And those of you that are in the EU, in fact, I've already seen a couple of people comment here that are saying they've commented here that they're in the EU region. But there's something called the Digital Markets Act. And what this was, I won't go into this in a lot of detail, but this is this was probably about 5 to 10 years ago that this all unfolded, where the EU went after and looked into companies like Google and Microsoft to understand whether or not they were stifling competition and whether or not they were giving consumers enough choices as it relates to technology. And I'm oversimplifying, I'm not getting into all the details, but I bring this up because even though that's consumer facing, it does make me wonder, and it makes me think about some of the same themes that we're seeing in the enterprise tech space. That leads me to think if the enterprise tech space is suffering from these same problems, then perhaps governments like the EU will eventually regulate for those same reasons the enterprise tech space. And one of the big things they talk about, two big things they talk about, are gatekeepers at the consumer level and interoperability. And gatekeepers being, do you have an option outside of, for example, Googling search results? Or if you I know now it's different with AI. We're not using Google as much perhaps in traditional search, but back in the early 2000s, we were using Google quite a bit. And the EU really looked into some of the behaviors of some of these gatekeepers like Google, and they determined that they were exerting too much power, too much influence over consumers. And then the other part of it was interoperability and whether or not different consumer technologies could operate and play nicely with other types of technologies. Now, again, this is all consumer facing. It's not to say that this will necessarily happen in the enterprise tech space, but it does make you wonder, because we're starting to see some of the same behaviors from big tech companies in the enterprise tech space. You have to wonder if companies like SAP, Oracle, Microsoft, if they will face some of the same scrutiny as Google and Microsoft did at the consumer level. What's sort of your non-legal knee-jerk reactions to that, Marcus?
Yeah, I mean, from a non-legal perspective, I think the Digital Markets Act in general, and let me preface this with, I'm an American attorney and I focus primarily on U.S. regulations and U.S. laws, but we practice in a global environment, and that's the environment that we all live in and we do business in, and you've got to be aware of these things. And I think, from a regulatory standpoint, my view is that the Digital Markets Act has been relatively effective in leveling the playing field and protecting consumers in the way that it was intended. And I think it does really foreshadow what is coming for the enterprise market. And, we kind of laugh and say, well, the government regulators don't really care about business to business transactions. And I think that is true. Businesses are deemed to be, sophisticated purchasers of these technology services. But in reality, that's not necessarily true. And I think, the likelihood that, you're going to be involved in software negotiation or a large scale digital transformation project more than once or twice in your career is probably not very high. And so you're coming to this, with one hand tied behind your back, so to speak, and the vendors have really all the leverage. And you want to look at, if you want to know where we're going, kind of look at where we're at now and where we've been. And I think there has really just been a lot of bad behavior in the enterprise space. And it's really across the board. You look at SAP, you look at Oracle, you look at Infor, in the way that they're trying to, capitalize on their market, generate additional revenue, and all of that is really, going to make government regulators look at them with a jaundiced eye and want to do something about it. And I think that is what is down the pipe here. How fast it's going to happen, I don't know. I think there's going to be, there's political implications in the United States with regulations, in the government's current stance on regulating tech, but I certainly think it's coming, and I do think it's going to be generally a positive development for the consumers of large enterprise scale software.
Yeah, and I think as a buyer too, we don't necessarily need to wait for the government to do something. I think there's a lot of behavior that I would argue is just as much the fault of the enterprise tech buyers as it is the enterprise tech providers, in that they sort of allow this sort of behavior. And I think that's what gets a lot of companies into trouble, is they take what a vendor sells them at face value. Maybe they feel like they have to upgrade to the cloud now because the tech providers are telling them they have to, or maybe they feel like they have to go all in on one solution versus a best of breed interoperable model, whatever. There's a lot of different things that a lot of times leaders just defer to what the software vendors are telling them. And so, I think that the key takeaway, or one of the key takeaways that I want to keep coming back to here today, is that you have choices as a buyer, and you're the one that's ultimately, you got to determine what's right for your organization. But I do think, to your point, I think government probably will step in at some point in the future. I just wouldn't wait for it to happen, to make the decision that makes the most sense for you and mitigate the risk the way you need to.
Yeah, I mean, you've got to look at this, with the old, caveat emptor perspective, buyer beware. And you just, the reality is, you can't believe the salespeople. You have to take everything that they're telling you with a grain of salt. You look at these contracts, and there's a lot more that can be negotiated in these agreements that people are not negotiating, that they really have to focus on and do their best to level the playing field. And I think it's hard when you're dealing with these large enterprise players, SAP, Oracle, Infor, Microsoft. How much leverage do you really have? And the reality is, I think you have more than you think you have. And without a doubt, as you're entering into a relationship with them, it's probably the most time the time you will have the most leverage in negotiating with them. And you've got to think prospectively and make sure you use that leverage to your advantage, not only for the project that is immediately at hand, but to govern that relationship for the duration of the life cycle of the product that you're licensing. I mean, it's not just a one-time thing here, right? As you negotiate these, you've got to put all the stopgaps in there to really govern that relationship for the next 10, 15 years and think that far ahead.
Yeah, exactly. Because these are long-term decisions. And now more than ever, you're making decisions and signing contracts that are increasingly hard to get out of. And the switching costs are going way up. And I think that's where the real pain is going to be felt in this industry, is when we see the next wave of ERP replacements or big enterprise tech replacements, where you've gone all in on the cloud, all your data's in the cloud, you've adopted these pre-configurations or whatever that the vendors provide you, and now you decide, okay, that worked for a while, but now we've outgrown it, or we found a better option. It's going to be super hard to switch to get out of that. In some cases, it's going to be cost prohibitive, and I think that's where the real pain is going to be felt, and where we might start to see some of these regulatory actions.
Yeah, I think that's right, and I think that's very much by design right now, right? I mean, there's incredible pressure, and a lot of times, I think they coerce their customers into transitioning from on-prem to cloud, or doing some sort of a major upgrade, which really isn't an upgrade at all. And they're utilizing every contractual trick and pain point that they have in those contracts to their advantage to get you to a revenue generating point. If you're pushing back on upgrading, you're pushing back on moving to the cloud, they have to find a way to generate additional revenue for you, and they're going to use that contract to their advantage. And that can be through audits, through termination rights, transition assistance, whatever it is, they will find a way to create a revenue generating event from you. And I think that is the kind of bad coercive behavior that people are going to look at and would drive government agencies towards kind of trying to implement some sort of a regulatory framework with that.
Yeah, absolutely. Well, I want to get to a few audience comments here. We've got D. Smith on YouTube joining from the Netherlands, part of the EU, obviously. So this is right up your alley and more directly related to you. Some of the stuff we're going to talk about here today. We've got Jorge joining from Monterrey, Mexico. Dr. Poland joining from Mauritius in the EMEA region. And then D. Smith commented or answered my question earlier, which is, do you think this space should be regulated or more regulated than it is now? And D. Smith on YouTube says yes for specific industries like finance, public sector, and pharma. Makes a lot of sense. I imagine public sector might be, or potentially healthcare, pharma, something that has more direct consumer impact. I imagine it would make sense that might be the first to get regulated if part of this industry is going to get regulated. And then I think from there, the dominoes continue to fall potentially, once you start in a certain industry. Keep in mind, again, this is more of my legal, since I'm with an attorney here, I feel like I have to give all these disclaimers. This is us anticipating, speculating what we think might happen. These are not guarantees. Results may vary, or whatever disclaimer I need to put in here. Sundis from LinkedIn's joining from Dubai. Thank you for being here today. Jacob Mass on YouTube joining from South Africa. We've got Zablon joining from Kenya. Thanks for being here. Hello, Sanjay on YouTube. Thank you for being here. Ken's joining from North Carolina. We've got Barry on LinkedIn joining from Panama, and Craig on LinkedIn joining from South Africa. So good South African representation today as well. Just a comment here from D. Smith on YouTube. D. Smith says, true story. Coming from SAP myself, I know that it's all about the numbers. And with the 20/80 rule, the 80% of sales reps would overpromise and underdeliver. I tend to agree with that. I think that's unfortunate reality of human behavior. You do what you need to do to get a sale done. And if it means hiding some of the risks or glossing over some of the details, then that's what you do. I'm not saying it's okay, but that is what oftentimes happens there. And I think that's part of the behavior, especially when you're talking about these big multi-million-dollar contracts. That's the type of behavior I think that leads to potential regulation, or it leads to, at the very least, regulators taking a look at this and looking under the hood of how does this industry work and what needs to change in it. One thing I want to do is shift gears a little bit, Marcus, and show this other. I'm actually going to share my screen really quickly just for part of this conversation here. And the reason I want to do this is just to show you this report. It's really interesting, and I know Marcus has seen it as well, but just for the audience's take here, this is the cloud services market investigation in the UK. This is a report that was published middle of last year in the UK. And what happened here is in the UK, the CMA, I believe it's called the Consumer Market, right here, the Competition and Markets Authority, a regulatory body within the UK government, went in to investigate the cloud market, basically, and really focusing on hyperscalers, looking at AWS, Google, Azure, with Microsoft, and just looking at the power and the influence and the level of competition amongst these really big providers. And the really interesting thing here that they talk about is that they talk about the nature of competition in cloud services markets. They talk about how basically the competition or the market share is heavily concentrated with a small handful of hyperscalers. I don't think they use the word hyperscaler in here, but that's kind of what we refer to them as. But you can see that they focus on Microsoft, AWS, and Google, and looking at their market share. And basically, to make a long story short, they've identified these three providers as companies that have a massive amount of control and power in the market. And when you get down to their conclusions, and they haven't yet given any sort of prescriptive recommendations, but that's forthcoming here in 2026. They say in this report that in 2026 they'll come forward with some recommendations of what to do about it. But essentially, what they say here is this sentence right here I want to highlight, because they talk about market concentration, which is particularly high in the case of infrastructure as a service, which is essentially these cloud providers. Barriers to entry and expansion are features that have enabled each of the two largest providers, Microsoft and AWS, to hold significant unilateral market power in the cloud services markets and to earn returns above the cost of their capital over a sustained period. Now, I don't think earning returns above the cost of capital is necessarily a bad thing. They have to make a profit. They have to get a return on capital. But I think the more important part here is that they're saying the unilateral market power. And that's where they're going here, is looking at, are there too high of barriers to entry? Are there possibilities for other competitive options in the space? And essentially what it sounds like they're saying is no, there's too high barriers to entry and there's not enough competition. In fact, they say right here, we think outcomes for customers would be better if cloud markets were more competitive. The outcomes would include more consistently competitive prices, greater prevalence of switching, and multi-cloud use, and potentially higher quality and innovation. One thing that's really interesting about this report, it jumped off the page at me. I don't know if you noticed this too, Marcus, but they talk about a statistic that says that less than 1% of cloud customers switch cloud providers in any given year.
Yeah.
And what they're saying is that right there tells you that there's not enough options and customers are getting locked in. I don't think they use the word vendor lock. That's another industry term that our industry invented, but they're essentially getting to this concept of vendor lock, talking about how hard it is for customers to switch cloud providers. So they get into some high-level, broad-stroke sorts of recommendations, but essentially what they're saying is that the CMS board is going to review further possible action and consider those actions in early 2026. So again, TBD on what this all means, whether it's relevant. It sounds pretty relevant to me. It sounds like they're going to do something. But the big question here, and by the way, this is all public record. If you just Google CMA Cloud Reports UK, you'll find this report. It's public record. I just found it on the internet through the UK government's website. So it's easy enough to find if you'd like to read it yourself. But it's a super interesting read. But what are your knee-jerk reactions to that, Marcus? And again, knowing that you're not an attorney that practices outside the U.S., what do you just think in general for the global enterprise tech space? What does this mean? Where do you think we go from here?
Yeah, no, I think it's hard to predict the future, right? But this whole concept of the inability to switch platforms is true, and it's really shocking that is the percentage, right? It's fewer than 1%, and that's certainly by design. There's anti-competitiveness associated with it. There's potential antitrust violations. SAP was investigated last year, but I think the investigation is still ongoing by the European Commission for doing just this, where they make it incredibly difficult to have other third-party providers come in, provide support, switch to a different provider altogether. And that is all by design, and it's something that's been going on for decades. I mean, when I used to work at SAP, and we very much knew who was an SAP shop and who was an Oracle shop. And if you were an Oracle shop, you very rarely were going to switch to become an SAP or Microsoft shop. And it's very much the same today. And like I said, I think that is by design. If you look at the contractual framework, you look at the clauses and the restrictions that are put in these agreements, everything is really biased and works against you from a contractual perspective, making it difficult and making it costly to switch. Once you're on a system, I mean, how do you transition out, right? I mean, you're looking at at least a 2-year implementation, I would think. It's not something that you can easily do, and I think you said it earlier in our conversation. I mean, there's a lot of blame to go around here, right? It's not just the enterprise providers, the software vendors that are doing this. It's that the customers allow them to do this as well. And I think, if you don't regulate yourself, then the government's going to do it for you at some point. And, from my perspective, I mean, I think I would rather do it ourselves. And how do you do that? Well, I think you've got to push back on these onerous contract provisions. You've got to use the consultants, the legal resources that are available to you when you're getting into these relationships to make sure that you are protected, and to make sure you've got the flexibility to do with that software platform what you want to in a way that serves your business. And it's all about obtaining as much flexibility as you can, despite that vendor's efforts to really put you in a box and try to create what I would call these revenue generating events from you as much as possible. I mean, that's how they view you, right? You are a cash cow to them.
Yeah.
And that is a viewpoint that I think is going to get them into trouble, and is the regulatory framework that I would envision. And again, I can't predict the future, but it's going to be something about I'll say this from a non-legal perspective or a non-technologist perspective, but data portability, right? Your ability to own what you have put into that system, and your ability to do what you want to with it without restriction. Your ability to use third-party products to interface with that software system without creating revenue-generating events that are unreasonable, and to have some level of transparency into the licensing metrics. I mean, you look at the way that SAP's contracts are structured now, you need a lawyer to look at that. And we usually have more than one just looking at that contract. I mean, they're very complicated. And to understand how they're generating revenue off of that software, it virtually makes no sense. I mean, I will tell you, I mean, they can't audit on some of those things either. I've worked at some of these large software vendors in-house, and the way they come up with the pricing schemes is not particularly scientific. I mean, they are flying by the seat of their pants sometimes, and that's why it may not make a lot of sense, and there's ambiguity around it. But I think some sort of regulatory framework that could really cut that ambiguity out of the revenue generating aspect of the software, and prevent vendors from leveraging that ambiguity to create additional revenue generating events would be a good step in the right direction.
Yeah. And you bring up a point that I forgot to mention from the report, the CMA report. One thing they talk about is the use of multi-cloud environments. So they also investigated how many customers are actually using multiple cloud providers. And what they found was not many. There's too many that are all locked into one big cloud provider, and very few are actually using a multi-cloud environment, which some would say, well, why would you want multiple cloud providers to begin with? I think their view is that's not the point. The point is whether or not you want it or need it. It's do you have the option? And they look at the overall industry and say it doesn't look like companies have a viable option to do that. Another thing that you kind of you led into, Barry on LinkedIn, who's coming in hot today, saying the quiet part out loud. He says, if you think the push to the cloud is to benefit the user organization, you haven't been paying attention. And I actually totally agree with that. I think there are some benefits to the cloud, but the hype around the cloud and the focus, the myopic focus, the blinders, let's only look at the cloud focus is coming from the vendors, because they make so much money and their stock prices do so well when they can prove cloud revenue and get that sustainable annual recurring revenue.
That's exactly what they want. And you look at additional ways they can make money, and SAP there's this concept of indirect access that has been around for a long time, and there was a case in the EU where if there's another platform or another machine interacting with your SAP system, it would be deemed to count against your user count. Right now, that concept is pretty well established, and in reality, that makes a lot of sense to me, the way that those contracts were structured and are structured. But what SAP is trying to do today is create another revenue generating event where, if you're trying to access your data in that system to train an AI model or an AI tool that is not an SAP AI tool, they want to extract as much revenue from you as they possibly can for you to do that. And where's the value add? Simply because your data is stored in their system does not give them the ability to charge you these exorbitant fees to be able to train a third-party tool. Now, is there a middle ground, and is there a seed of reasonableness on their side? Probably, right? We could talk about that, and it'd be an interesting conversation. But the point is that these companies are doing everything they can to commercially exploit your use and utilization of their software, and at some point, it goes beyond what's reasonable. And that's where the problem really is, right? When you start using contractual provisions and restrictions, and I'm thinking primarily of audit restrictions, termination provisions, um, fees for assigning the contract. When you start using these in a way that goes beyond basic contractual enforcement, that's a problem, right? When they start using these to coerce their users into making a transition to the cloud, doing a major upgrade and saying, well, look, you're on the hook for, $50 million because of this audit, but, we'll make that all go away if you do a $75 million upgrade or something like that. That is, violating what we call in the legal industry, the duty of good faith and fair dealing that's in every contract, and that is a breach of contract. So, there are mechanisms now, but I think, these guys play fast, loose, and incredibly aggressive. And, that's what's going to lead to regulation.
Yeah. Now, how about the fact you alluded to this just a moment ago, and I want to dive into a little bit more, but if a lot of vendors are doing this, and you could argue, if I'm a vendor and I could argue that I'm not doing anything wrong, this is industry standard, this is just how the industry operates. I use that as a defense and say, well, yeah, I have the right to do audits. Yeah, I can create this vendor lock, situation contractually, but so does every other vendor. So I'm not doing anything wrong. Is that what are your thoughts on that? That's where one thing where I get stuck a little bit, because I've done expert witness work for you and other law firms. And I know that's a question that I get asked in court is, well, is that industry standard? And a lot of times, no, it's not. And then it becomes a big deal. And you and the other attorneys fight over whose fault that is. But if I say, or anyone were to say, yes, that is standard, does that make it okay?
Well, no, of course not. It doesn't. It does not make it okay. And I think, and we said this a few times during our conversation, what are we allowing the vendors to do, right? And I think this is where, these European regulatory frameworks can actually provide some beneficial leverage in the context of negotiation, because you can hold that document up, right? You can grab that and you can point to your vendor and you can say, look, the European Commission or whoever it is has said that what you're doing here is anti-competitive. What you're doing is unreasonable, and it's something that they're regulating in a foreign jurisdiction. Now, they may not be regulating it in the business to business context. It may be in the consumer context, but at least it gives you, some sort of a dog in the fight to push back on that when they're trying to do these things to you. But I also think you've got to go into this fully aware. And the document that governs your relationship with your vendor is the contract. And if you don't put adequate stopgaps, mechanism for control, and language that gives you flexibility, you're walking right into this. And in some ways, you're just as much to blame for the situation you get into as the vendor is, because you've allowed it to happen. And, I think, self-regulation is going to be certainly better than government regulation, but not everybody has, the sophistication to properly negotiate these contracts or the experience to understand what they're getting themselves into.
And that's why, hiring people like you or I and others to help through that process can be so powerful. And it certainly is a lot cheaper to negotiate that stuff up front rather than waiting for a failure or waiting for the government to step in and help you out later, because that may or may not happen. So you talked about, you started to talk about audits, audit behavior. And there's an article I just read last night, actually preparing for this interview. I went down a couple rabbit holes along the way, but one of them that I went down was around Microsoft and how they're announcing that starting this month in January of 2026, they're going to be auditing D365 user licenses. It sounded like that, from what I understand, it's the on-prem D365 user licenses. They're going to go in and start doing these audits. And we've seen a lot of vendors do this. You and I have talked about this before. I know I've seen it from SAP. I've seen it from Oracle, certainly Microsoft. We've seen it from IFS. We've seen it from Infor. Yeah. I don't know that I haven't seen this I can't think of any vendors where I haven't seen this, at least of the ones that started off on-prem and are now making this push to the cloud. A lot of these vendors are saying, hey, we come in, we do an audit. And by the way, you owe us $2 million for all the licenses you've been using illegally or, outside your contract for the last 10 years. So you either pay us the $2 million or here's a better idea, upgrade to our cloud solution and we'll make it all go away. And so I guess we see it a lot, and it's crazy. It's crazy behavior, even though they legally, contractually have the right to do that. It's just, I guess that maybe it's not a legal issue, it's an ethical issue. What are your thoughts on that? Like, how do we navigate that reality in our industry?
Yeah, and look, you've got to have clarity on the front end, and I keep saying this, but it's true. And you've got to be able to anticipate what's going to happen. And you're not just negotiating a contract for today, but you're negotiating a contract that governs that relationship for the next 5, 6, 7 or more years. And you want to have the price, the price caps. You want to have future options. You want to be able to switch out users or switch out functionality or modules. All of those things are some of the tools in the toolbox to be able to push back on the weaponization of these audits. And I think they do this purposefully, right? And the fact that you said they're going after legacy on-prem users doesn't surprise me in the least. And it's just for what you said, right? That they want to transition you to the cloud, and they want to do that because it's a huge revenue opportunity for them. That's I think it was Barry again says subscription licenses or perpetual licenses are worse than subscription licenses because they're perpetual, right? I mean, you're getting as the vendor this perpetual lease on the software, which is going to generate much more money for you over the long term, and that's exactly what they are trying to do. But I think they will weaponize the complexity of the licensing scheme. There's going to be a lot of ambiguity in that contract about how fees are generated, when you're supposed to pay, and you will do your best to be in compliance with that contract, but they will be able to point to situations where you are so-called out of compliance, and it will be a gray area, and they will use that gray area to your advantage. And this is prevalent, and it's coming up more and more. We just had a meeting in our software licensing practice group where we were talking specifically about this, and we talked about Oracle in particular. And I will tell you, I just sued Oracle for what we deemed to be an over-aggressive audit. Now, it was related to Java, so it wasn't in the context of trying to get somebody to switch over from legacy on-prem system to cloud, but certainly it was aggressive. The money that was being asked for was over the top, and the response was, well, the middle finger by my client, and we're going to take you to court. We did that, and of course, we put Oracle on their heels, and they came to us with a much more reasonable posture related to negotiating what they deemed to be the unlawful use of their software. So you don't want to have to do that, but sometimes you've got to stand up for yourself, and you got to push back hard.
Yeah, absolutely. And coming back to that theme, right now it's up to you, it's up to us to manage this. We can't rely on the government. But to your earlier point, a few minutes ago, if this industry doesn't learn how to regulate itself, it will get regulated by someone, and presumably it's going to be multiple global government regimes that'll do it. That's probably going to be a lot more painful than if we just figure out a way to play nice, be ethical and be above board. And speaking of that, here's another comment from D. Smith on YouTube. He says those hyperscalers cause the smaller niche players to be disqualified for not being on their marketplace when that partner might bring the best solution to the customer. And I bring this up, and I want to broaden this a little bit too, because there's a couple other legal issues that we haven't talked about yet. One is there's a couple lawsuits against software vendors, specific software vendors, for not having enough openness to their technology. So, for example, Celonis is suing the SAP in the United States for basically blocking out their technology. And Celonis is a business process mining tool that goes into multiple technologies to analyze what's actually happening in the system and how people are using the system, transaction times, all that stuff. It's a way for you to understand how processes and workflows are actually working. So Celonis is suing SAP, saying, hey, SAP is locking us out to where our product can't work with SAP because they won't allow it to. And the reason for that, they allege, and one has to presume, is because SAP owns their own business process mining tool, and they want customers to use that. They don't want you using a third-party solution. Epic Software, which is an electronic healthcare record provider, I recently did a video about this. They're getting sued by, I forgot the name of the company, but it's another technology provider that provides ambient technology in the healthcare space. And they're suing Epic, saying that their ambient technology provides better, this third party ambient technology provides better health outcomes, but Epic won't allow integration with that solution because they're developing their own ambient technology that's not ready yet. So they're saying, they're going a step further and saying, not only are you harming us, the company, but you're harming consumers and their health. And so that'll be an interesting one to see how that unfolds. I think that one's taking place in the United States as well. So we're starting to see legal action against these software providers, basically demanding openness, interoperability, and we're starting to see more vendors provide it, despite all the vendors that aren't. We're starting to see companies like Boomi has become a big deal because they provide interoperability. They provide integration between systems. Palantir, Rapid, even QAD, the traditional ERP vendor, is now shifting gears and saying we're more of an AI interoperability software provider, not an ERP provider. So some companies are riding that wave of what consumers want, but others are resisting it and trying to block, kind of stop it from happening. So I don't know what any thoughts on that, Marcus, just in the way that are software providers obligated to provide openness and options and transparency and that sort of thing?
Well, to answer that question, simply no, they're not necessarily, right? But I think they open themselves up to these types of criticisms, these types of lawsuits. I did a video on the Celonis SAP lawsuit not that long ago, and I think that's a classic example of where the problem is, right? It's not because the Celonis technology was bad or it introduced some vulnerabilities into the SAP system. It was solely because SAP wanted their own customers to use the SAP functionality that was similar to the Celonis functionality, and they were going to make the Celonis functionality prohibitively expensive. And that's just unfair, right? That is unreasonable. Now, if you've got a reasonable basis for charging a reasonable fee to utilize a third-party product, that's one thing. But to do it only because you've got an anti-competitive, activity that you're trying to engage in, that should be taken to court. That should be illegal. And I think companies that are doing that need to tread very carefully. And the whole benefit of these platforms like Salesforce or these open platforms is that all these niche players can come in and make the totality of that system better. And that's a hard nut to crack for some of these vendors that have these massively closed systems. They don't want to do it. And I think if there's going to be some regulatory oversight, that's that's certainly one place to start.
Right. Yeah. Now here's an interesting. This is actually I love part of the reason I love doing these podcasts is because I learn from people like you, Marcus, and I learn all the stuff from the audience too that I didn't know. But this is from Lean on LinkedIn. Says, "What's your view on this? The EU awards an 830 million euro SAP deal despite looming antitrust investigation." And actually, while we were talking here, I just Googled it. I wasn't aware of this. I didn't know that the EU had just recently, as just a few months ago, embarked on engaged in a pretty extensive contract with SAP. And so you mentioned this before, Marcus, that the EU is investigating SAP for potential antitrust behavior. Right. We haven't really gone into that in a lot of detail, but I think that's another signal that we're seeing in the market, another smoke signal we're seeing. But I do find it interesting that despite the fact they might be anti-competitive, despite the fact they might be doing all these things, then the EU government turns around and pays, presumably it'll be a lot more than 830 million if that's what the face value is on the contract. What do you make of that? Because I wasn't aware of this. I didn't know about the EU signing this big contract.
No, I wasn't aware of that either. And I think that is one example of the hold that these vendors have on the user base, right? I mean, you don't have options. And I mean, you can look at this in a variety of ways. You can say, well, these guys are just corrupt and they're saying one thing but doing another. Maybe there's some element of truth to that. But what options do they have? These are the major players, right? There isn't, at least in the EU's view, in connection with awarding them an $830 million or $830 million euro deal, there wasn't a viable competitor that made sense to them. And did they want to use SAP? I would think from an optics perspective, maybe not. But there weren't a lot of options. So they probably didn't want to use Oracle, an American company, and so then who are you going to use? SAP is probably the premier European ERP vendor. So on one hand, it's safe to use it.
Especially if you want an EU-based company. I mean, that really is your main option.
Right.
Very interesting, though. I actually read here as we were talking that as I was multitasking here, trying to dive into this a little bit more, I saw here that SAP, part of why they might have invested in SAP is because apparently SAP has also been investing heavily in its EU AI cloud and so sovereign cloud offerings to support European digital sovereignty and data residency requirements, committing over $20 billion to the initiative. So that alone might be a good reason why they chose SAP, because if they've got the sovereign cloud that's hosted all in the EU and it meets regulatory requirements more than, say, an Oracle or a Microsoft or whoever they might consider, that could be part of it as well. But still very interesting. I don't know who that gives the leverage to, or who gives up leverage as a result of that relationship now, but it should make for an interesting unfolding of that whole antitrust investigation for sure.
Yeah, and I mean, you can see this. I mean, these are not easy answers, right? I mean, there's no easy definable path forward on how to get out of this and to predict what's going to happen. I mean, you don't have a lot of options, and trying to make the market more competitive is really challenging. I think. I mean, there's how do you compete with Oracle, SAP, Infor, Microsoft, or any of these top tier players? I mean, sometimes the third tier just isn't good enough. And so what do? You don't have a lot of options but to go with some of these companies that are maybe engaging in some of this bad behavior.
Yeah. Do you think things are getting better for as far as buyers and leaders within organizations that are signing these cloud contracts? Do you think they're being more successful nowadays in pushing back on some of those terms than they were maybe 5 or 10 years ago, or is it more of the same?
That's a really good question, and I think it's twofold. On one hand, no, I don't think they're being more successful, and primarily because I think the software vendors have really circled the wagons. I used to work at SAP many years ago and have dealt with them on a negotiation basis consistently over the years, and I would say, up until about 5, maybe 7 years ago, SAP had a more customer-friendly approach to negotiating these types of contracts. They were willing to negotiate, they were willing to offer concessions, and they were willing to be generally reasonable in the way that they approach their customer relationships. Oracle's never been that way. Oracle has always been it's our way or the highway. If you don't like this, go somewhere else. SAP, though, I would say in the last maybe 5 years has really changed their position and become much more aggressive. They're unwilling to really deal with you. They're unwilling to accept reasonable concessions, and it's very difficult to negotiate with them in the current environment. And so I think what has happened is customers have become more sophisticated, and they engage consulting firms like Gartner, they engage firms like you, they engage law firms like mine to help them negotiate these contracts. But the willingness of the vendors to actually make concessions has gone down. And so, you've really got to prioritize what you're going to, focus on. And, I do think, though, if you're really only going to be focused on the amount of a discount you're getting off the list price, and that's the concession that you're really going on, you're really doing yourself a disservice, because all of these issues associated with flexibility, additional revenue generating events are going to come back and bite you, and you're going to end up spending much more money over the life cycle of that product than you would just by focusing on the discount. The discount is going to be small compared to the amount of money, extra money that you're now spending. So you've really got to push and fight to make these agreements reasonable. And it's not an easy thing to do anymore.
Yeah. So when it comes to documentation and internal governance and other areas of an organization's approach, what should organizations be doing when preparing for some of these licensing or audit disputes? If you, or at the very, let me back up and ask it, how do we avoid the licensing or audit disputes? What can leaders do to protect themselves and make sure they're not getting locked in and not subject to some of these aggressive audit tactics and other behaviors that you've talked about so far? What can we do to protect ourselves against that?
Yeah, on the front end, as you're negotiating these contracts, you got to give yourself a dog in the fight. You've got to have an appropriate amount of flexibility to be able to utilize that software in ways that make sense for you. You want to anticipate, use that's beyond the scope of what you're getting today. Whether that's through the ability to buy additional software, additional seats because you need them to leverage any future discounts that you've got if you're going to buy additional seats, the ability to trade out modules. It's all about this kind of flexibility without generating additional revenue for the vendor. If you can do that, you're going to minimize their leverage against you. Having some insight into how that software is licensed, how the vendor is making money off of that particular license metric is going to help you. A lot of times it's ambiguous. Now, what we will do if we're in the throes of an audit is, we want to really conduct a self-audit. And that's where having the documentation, having an understanding of how your organization is utilizing that software, having an understanding of a reasonable read of that contract, interpreting the license grant, the scope of limitation on use in a reasonable manner, and then generating an analysis of how reasonable is what that software vendor is asking for. How reasonable is it, right? Based on my interpretation of the contract, they're going to say, "Oh, I'm $50 million." Well, not really. Based on our view and the way we read this contract, it's $1 million. Okay. And so you've got to have the ammunition to fight back against that vendor. And then it really becomes a matter of picking a number. And if you're not happy with where that is going, you can always sue the vendor, right?
Right.
And there's a lot of legal theories behind, what are you going to sue them because? What are the causes of action that you're going to assert? And that's a different conversation. But that is very much an option. And nobody likes to sue their vendor, but you have to understand the vendors don't want to sue you either, and they don't want to have their licensing schemes, their audit schemes tested in court. So in my view, it's a nuclear option, but it's a reasonable option, and you can only sufficiently leverage it if you have done the due diligence on the front end, you've documented how you're utilizing that software, you've done a self-audit, you're able to push back on the vendor and have an articulate rationale for why their interpretation of the contract does not make sense at all.
Right. Yeah. Makes total sense. So what closing advice would you give to, beyond what you just said, any other closing advice you'd give to project teams and leaders that are trying to navigate or anticipate what might happen from a regulatory perspective, and how should we navigate our own legal risk or manage our own legal risk in the meantime? What's your closing advice?
Yeah, I mean, I think the takeaways are really two to threefold here. And I think, the first one is regulatory oversight is coming. And I don't know what it is going to look like specifically, but I think you can look to the EU for at least a playbook and to kind of have an understanding of what might be adopted here in the United States or in other jurisdictions around the world. And I think that can be a good thing. But I think in the meantime, you've really got to self-regulate. You've got to hold these vendors to account. And you can't look at these contracts in isolation. You're not just negotiating, a kind of one-time event type deal and you're done with it. You can't, so to speak, set it and forget it, right? This is a dynamic relationship that is going to be governed by this contract that is going to be necessarily imperfect. You're not going to have an understanding of the scope or your future utilization of the software. And you really need to think as prospectively and broadly as you can as you get into these contracts to try to avoid the restrictions that are going to be put in place on you. It's all about flexibility in the future, not incurring additional revenue for running your business the way you want to run your business. To me, those are the main takeaways.
Yeah, that's great advice. And I appreciate you joining and help us unpack this really interesting topic in at a very early stage. Hopefully we can get ahead of this and navigate it better than we have historically as an industry. So I appreciate you being here today, Marcus.
I appreciate the invitation. This is a really interesting topic, and I think it's going to change, rapidly in the near future here. And I think, having an understanding of it is going to be key to getting the best deal you can.
Absolutely. Yep. Good stuff. Well, thank you again. Thanks to the audience for being here today. Hope everyone's having a happy new year. Be sure to check out our podcast, Transformation Ground Control. Go to transformationgroundcontrol.com. You can see past episodes of that show, and we release new episodes every Wednesday to all the major platforms. Whatever platform you're listening to or watching on right now, we'll release it to those platforms as well as the audio-only platforms every Wednesday. So check that out, transformationgroundcontrol.com. Hope you all have a great week, and I look forward to seeing you all soon.